You maybe heard recently that in August, a judge from the BC federal court named Barbara Young gave about $500 million worth of public and private property to the Cowichan tribes in a land claim settlement. This has led the city of Richmond, where the land was taken, a suburb of Vancouver, to write to 150 homeowners and say, we can't guarantee that you won't be kicked off of your private property because of this decision. It is a genuine concern. It's interesting that this decision probably violates one of the most recent decisions on land claims by the Supreme Court, which itself is very activist. In 2014, the Supreme Court said, well, you have to prove continuous, exclusive use of a parcel of land before you can make a land claim on it. It has to be before and after encroachment by Europeans. This doesn't seem to fit in the Cowichan case. The Cowichan used this parcel, about 3¼ square kilometers, as a seasonal fishing village. They would come over from Vancouver Island, where they lived. They would set up a temporary fishing village in this area. They did it every year, absolutely. And they seemed to have been the only people who were using that particular little chunk of land. But it wasn't their permanent settlements. They'd catch a whole bunch of salmon and they would go back to where they lived. That doesn't seem to satisfy the Supreme Court test. However, Justice Young decided that they should have Aboriginal title to this chunk of land, which allows them to occupy, control, use, or divide the land any way they want to do it. And I think the thing about this that should cause most Canadians concern is that an activist judge has ruled over fee simple property ownership to give First Nations what they're demanding. Now, BC is an exclusive case because most of BC is not covered by treaties. Most of the rest of Canada is covered by treaties from the 18th, 19th, and 20th centuries. And in most of those treaties, it's quite explicit that the First Nations involved were giving up Aboriginal title in return for reserves and benefits, healthcare, education, and all sorts of other benefits. The federal government now spends $32 billion a year on 1.8 million Indigenous Canadians. So it would seem that those 9 provinces, other than BC, are well cared for, well taken care of. You're not going to get a property ruling like you did in Richmond B.C. But I can't say, I know no one who could guarantee whether an activist judge would say, look, the federal government hasn't lived up to its end of the treaty bargains, so therefore I'm going to invalidate the treaties and I'm going to give Aboriginal title to First Nations in any of the other 9 provinces. I absolutely believe that could happen. And so I think that the Cowichan Tribe's decision in BC threatens private property in most of Canada. For Postmedia, I'm Lorne Gunter.